What's going on, everybody? Thanks for tuning in to another episode of the California Underground Podcast. I am back from my travels. It's been 2 weeks. Thank you to Camille last week for hosting the episode with Amy Reichart. It was a great episode. Sean Fredrickson as well. Thank you for hopping on while I was away. My travels caught up with me, and I'm a little sick. The jet lag between Europe got to me. So that's not the point of this episode, though. We got much more important things to talk about tonight. That's why we have John Dillon on the show. Attorney Dillon Law GP. He's behind the ruling that just came out. Huge Earth Amendment news. The assault weapons ban in California has been deemed unconstitutional. And for all those watching or listening right now saying, yes, we already knew that. Well, it's because we have a new Supreme Court ruling, and John's going to get into all that. So, John, welcome to the show. How are you doing tonight?
Good. Thanks for having me. I'm doing well.
Awesome. So why don't you do a little bit to introduce yourself, tell people who you are and how you got involved in like this area of law, and what you've been doing in it so far.
So, all right. Well, my name's John Dillon. I'm the principal partner of the Dillon Law Group in Carlsbad, California. Born and raised in Southern California, San Diego. Went to law school at Loyola Law School. Funnily enough, I kind of owe it to California for my career. In law school, I had a big period of time in between the classes where, I didn't want to go and research or, read in the library. And I didn't want to drive back through LA traffic to get home. So I actually started shooting at the LA Gun Club because it was down the street from my law school. So after a little while doing that, got into shooting, bought my first gun. A little time after that, I started tinkering with the gun. Everyone buys a Glock, and you can't actually leave it the way it is. So I switched the barrel out, try to get a match grade barrel or something like that. And I was on a online forum back then, and someone tells me that I committed a felony in California because I changed the barrel on my pistol. And the 21-year-old me panics, I freak out. I race, into the law school library, start trying to research the penal code, figuring out what my legal defense is going to be, because I figured the ATF and the DOJ were going to, climb through the window, kick down my door, and shoot my dog. So I am reading this law, trying to figure out okay, what do I do? What do I do? Learn that in fact I didn't actually commit a felony by changing the barrel on my pistol. But while reading these laws, I started to be like, well, that's kind of a stupid law. And well, why are they doing that? Why do they require you to wait 10 days? Like, what the hell is a cooling off period? Just all sorts of stuff. Like, what's a handgun roster? Why is the blue Colt Python okay, but the silver one's illegal and, not safe? So that kind of just turned into a weird obsession while I was in law school, because, when you're in law school, I don't know if you had the same experience, but when I was in there, when they came across the Second Amendment, they were like, a well-regulated militia, basically that allows you to keep and bear arms as long as you're part of a militia, and that's about all we need to say. And then they just moved on. I think we spent more time on the Third Amendment than we did on the Second Amendment, in every other amendment. But so that kind of obsession just rolled into after I got my license to practice law. I started working down in San Diego, and somehow convinced the partners of my old firm that, hey, California is a insane place when it comes to gun laws, and there's not a lot of attorneys that are really practicing strictly in firearms laws. So I think there's a little market here, and I think I can do something. And shortly after I convinced them to do that, I just started rolling in it and trying to find clients, figure it out, just learn the law myself. And I met up with Michael Schwartz with San Diego County Gun Owners right after the time where he just kind of created that, and hooked up with him, like-minded individuals, and went on from there. And then around actually the start of COVID, I left my old firm and I started my own firm that our main focus is firearms regulation. That's kind of how I got here.
And so obviously when you went in and researched in the law library, and the more you dug, is how utterly all these gun laws are and how none of them make sense.
And
correct?
it was crazy. as someone who I admit, when I was my first year in law school, I didn't know anything about Constitution. I didn't know anything about the Second Amendment. I had a vague interest in guns before I started buying guns and started shooting. But I was woefully ignorant, and I would say I was woefully ignorant, like a lot of the population in California, when it comes to their fundamental rights, unfortunately. And so just started reading this stuff and not really having an opinion or a position, whether it be left or right, or pro-gun, anti-gun. I quite literally started reading the penal code, thinking that I needed to come up with my own legal defense. And so I think reading through everything, I really had an objective view of these laws when I read them for the first time. And just over and over again, you read these things and they don't make any common sense. There's no rational basis for it. And it just perplexed me going through it all. And then I started reading about stories of people actually getting in trouble and getting arrested and having convictions based off of these weird technicalities when it comes to gun laws. And I thought that was just an absurd process. And as my wife say, I delved in deep into the obsession in law school, and it's the thing that keeps me going. Being a lawyer is not always fun. It's not like the TV shows, but when you get to do stuff like the Second Amendment, it's always a good time.
I can agree with you there. It's not always glamorous like Suits or anything like that.
I don't really have a lot of alcoholic drinks in the middle of the afternoon on a work day. I see that a lot, but I've never experienced that.
Yeah, I've never had the martini lunch, like people always say, or the liquid lunch.
Yeah.
But speaking of ridiculous gun laws and how silly and they don't make any sense, let's pivot now to obviously this huge ruling, Miller versus Bonta, which you were a part of. And this is a law that Second Amendment people in California looked at this law and said, this makes absolutely no sense. You can tell it was written by people who don't understand guns. And I will admit, I was reading the decision today. I got through about 50% of it because there's just so much there that Benitez put in the decision. But let's start at the beginning, how you got involved in this specific case and how you attacked it against the state, and sort of what was your strategy.
Yeah. So, I worked with the Firearms Policy Coalition, the Second Amendment Foundation. I mentioned the San Diego County Gun Owners Association. So, we all got together and it was, determined that, hey, we got to challenge this assault weapons ban. At the time, the Rupp case was recently filed. That was the challenge to the assault rifle provisions in the Central District of California. And, the thought was like, no, we got to challenge the whole thing. This is ridiculous. We go through iteration and iteration of, what an assault weapon is. I mean, if you go back to the beginning, the 1989 Assault Weapons Act in California, they banned guns based off of their make and model, the named guns, the named assault weapons. After, so many years of that, the state was like, well, we're not stopping people from buying these guns because they're buying guns under, with different names. So how else can we ban a large group of guns, without having to name them each individually, by make and model? So they determined that, okay, well, we'll just ban them based off of, their various features or the characteristics. And that was back in 2000. And that's when you get the first iteration of, a semi-automatic center fire rifle with, pistol grip, folding collapsible stock, vertical foregrip, flash hider, all that kind of stuff. So, we filed in 2019 challenging, the full gambit of the Assault Weapons Control Act, all the definitions, including rifles, pistols, shotguns. And the strategy was this. We had DCV Heller, came out in 2008. And, ever since I first read, that case, it seemed pretty clear on, how the analysis should go. We unfortunately had a good decade or more of a time where, the Ninth Circuit and other, courts of appeals, they made up this weird concocted analysis of how they determine whether a gun control law actually violates the Second Amendment. And funnily enough, it always seemed to end up to where the state was somehow able to justify any one of these bans. So we knew we were going up against that, scheme, and we knew that we were going to have an uphill battle from the very beginning. But we thought the time was right. It needed to be challenged, and the fact is we've always had Supreme Court precedent on our side when it comes to DC v. Heller. It was just a matter of getting a court to hear and understand and truly apply what the precedent was when it comes to, can you ban guns that are in common use? So that was kind of the beginning stages of it. And again, we filed in 2019 and went from there. And the Bruen decision, which came out was last year now, that obviously was a game changer completely. It changed the landscape, in every way when it came to Second Amendment cases. And, I think a lot of times, when it came out, the media and the press and everyone was talking about the concealed carry, conclusion, and the fact that New York can no longer require good cause for concealed carry, and then how that's going to be, have an effect across the country. But, and I'm sure you noticed this as well, but anyone who kind of has been following Second Amendment cases, following, the dissenting opinions when writ of certiorari gets rejected, from Justice Thomas, they saw the writing on the wall that, the test that the lower courts were using was wrong. And when we got the Bruen decision, we got a complete rejection of this made-up test. And it really pulled things back to is now forcing lower courts to apply a standard that's much harder to get around than what they were previously working with.
So this case had gone up, and the Supreme Court had remanded it back down because of the Bruen decision.
So yeah, what happened is we filed for a preliminary injunction in the district court. We had an evidentiary hearing on that. Additional briefing was submitted, and we actually then had a hearing, a trial, where we had witnesses testified, cross-examined, experts, all that, submitted all our evidence, and then the court consolidated that and made it a hearing on the merits. And so we had a full trial on the merits for determining whether the Assault Weapon Control Act was constitutional. The district court came back and said that, no, this is not constitutional, and it was going to be enjoined. Now, that was all pre-Bruen. So this was before the Bruen test. We were actually successful, and we were the first district court in the country to come back with a decision that an assault weapons ban was unconstitutional. So that was a big win, especially considering the fact that Bruen hadn't even come out yet. Shortly after we got that decision, just like we're seeing today, the state appealed, and then they also went for an emergency motion to stay the decision pending appeal. And so what that basically means when they're asking to stay opinion is the district court came out and said this law is unconstitutional. In 10 days, this decision goes into effect, and the assault weapons ban will no longer be enforceable by the DOJ and police. So the state came in, they asked for an emergency motion to stay, and that means you got to put a pause on that, put a pause on the decision until we go through the Court of Appeals, and the Court of Appeals looks at the case. That stay was granted by the Court of Appeals, and then shortly after that happened, though, the Bruen decision came out. And so before any briefing on the merits on appeal happened, no one did an opening brief, no opposition, no reply. We never actually made any arguments of any kind in front of the Court of Appeals. The case was vacated and remanded back down to the district court to be, consistent with Bruen decision. And that happened to, I want to say, almost every single Second Amendment case that was going through the courts. A lot of courts of appeals remanded their cases back down the district court because, like I said earlier, before Bruen, they were applying this test. It's a two-part test with a sliding scale is kind of how the district court in our case categorized it. But basically, it was a balancing of interests where the court or the state would basically say, well, these are the reasons why we have the ban. We think it's for public safety. We think it'll save everybody. not really offering any real concrete evidence that it would do that. But under the old standard, courts would be like, well, the reasoning that the state has to stop mass shootings and to protect public safety, those are good reasons, and so we uphold the law. And that was essentially what the test was. And so when it came back down, the courts were like, look, you got to now apply the Bruin standard, because the decision in Bruin outright rejected this balancing test, said you cannot balance the interests, you cannot do any type of means and scrutiny analysis. And so we went back in front of the district court. The funny thing is that the way we argued the case, and in fact, the way the decision first came out, is the district court actually applied the Bruin test before the Bruin test was labeled that. They called it the Heller test, and it was a factual matter of like, are these firearms in common use? If they're common use, then they can't be banned, and that's the end of story. And so the court actually came up with that decision on its own before Bruin, but then it also applied this old Ninth Circuit or Court of Appeals standard where they balance the interests, and still came out in our favor. So after it came back down, court requested some additional briefing to specifically address what Bruin said. We submitted multiple briefs on that, summarizing and analyzing the case and its applicability to our case at hand. Went back and forth. Let's see, I think there was a supplemental brief, and then responses to each of those briefs that were all provided to the court, all addressing Bruin. And then in December of last year, the court actually called for a hearing, a conference, where he brought in all parties. And in fact, they brought in the parties for the Fouts case, the Duncan case. That was the recent magazine ban case, the Rhodey case, which is a challenge to California's ammunition regulation. So they were all in front of the same court. So he called everyone in, and at that hearing, he told the state, look, I'm going to give you a few months. I want you to compile any and all laws, historical laws that you have, that you can find, that would justify this ban. And so, in a couple months' time, give me a list. I want the date of the law, what the law was, what it did, if it was ever challenged in court, if it was ever held unconstitutional, if it was ever repealed. I just want a giant list of all the laws that you think support this ban. And then about January, February of this year, they submitted a big old pile of laws. I think it was around 316 laws that covered over a 500-year period of time. And the state was like, this is our justification for the assault weapons ban. The court actually issued a minute order after that, stating, now that I have the survey, I want the state to identify the most relevant analogous regulation for the assault weapon ban that would justify it. So give me your best law that you say justifies the assault weapons ban, and let me know what that is. And the state came back and stated that, I think it was a 1771 New Jersey law regulating trap guns or booby traps. And that was the reason that the state can now ban the possession, use, transfer, ownership, sale of assault weapons. And it, not shocking to me and all of us working on the case, because we looked at these laws and we saw them and read Bruin, but you'd think with the entire power of the state using all our tax money and hiring all these experts, they'd be able to come up with more than just a single law that didn't even regulate trap guns. It just regulate setting them up and killing certain game animals with them. So that was the big, justification for the law. And because of that, we got the decision we did a couple days ago.
Before I ask my next question, what was the rationale that this trap gun or trap had anything to do with the assault weapons ban? What was their rationale for that?
Yeah, so the rationale was that this 1771 trap gun regulation was a sufficiently analogous regulation on the regulation of dangerous and unusual weapons. And because of that, they can now regulate any weapon that they deem dangerous and unusual today. Me saying that's assault weapons. And it's funny, we got in the decision that we got, the court actually specifically addresses this issue and goes and looks up the entirety of the law that they reference, and it actually kind of calls it out, saying this isn't even a regulation on the ownership and possession of trap guns. Under this law, you can buy, sell, transfer, own, possess, and even use trap guns. You just can't set these trap guns in order to hunt certain game animals. And so to say that that law is the equivalent of the assault weapons ban, which it makes it a felony to own a gun that has a pistol grip or a flash hider or an adjustable stock, it's just an absurd leap in logic. And anyone who has any objective standard whatsoever can't look at those things and be like, okay, that doesn't work, you know?
Now, before we kind of dive more into this specific ruling, I think it's important for listeners to understand how impactful it was. So when Bruin came out, I had read the decision and said, this is great for carry and conceal, but this is an earthquake for Second Amendment jurisprudence across the country because they changed the whole test. So can you go into a little bit for people to understand why is Bruin so big and so monumental, and why is it changing everything now?
Yeah, so it's really true. The change in the standard of how courts are going to look at Second Amendment cases, you said it was an earthquake. Yeah, it was Mount Vesuvius, Pompeii eruption, in my opinion. That the fact that the court explicitly called out this old two-part test that was being, used by a majority of the courts across the country, of the lower courts across the country, were applying this two-part test to Second Amendment cases. And it was, to say it was an uphill battle, for gun rights is a huge understatement under that test. Like I said earlier, literally any justification that the state could come up with was sufficient to justify any type of gun regulation. And I'll give you an example. There's a case, Sylvester v. Harris, back in 2016, where they were challenging the 10-day waiting period in California. And the unique thing about this case is you had plaintiffs that were concealed carry holders and or gun owners. So every one of the plaintiffs challenging the law was already owned a gun, or literally had a gun on their hip while they were going into a store to buy another gun. And the argument that they made was like, look, we go in and we instantly pass the background check. We have a gun on our hip. We're law-abiding citizens. There should be no need for a 10-day wait if we've already passed the background check, especially since, we have a gun. And cooling off, what are we going to cool off from? If we wanted to commit a crime, I'd use the gun that's on my hip, or I'd use the 10 guns I have at home. So they made these arguments to the court, and the state's response to this was along the lines of, well, if they wanted to commit a crime with a new gun, the cooling off period would help. And I don't think I need to really go into a lot of detail on that. But so they said, they still need the cooling off period. And in that case, they actually didn't present any evidence ever that the cooling off period has ever stopped a crime, made someone change their mind, anything like that. So that's the situation you're in. The court heard all this and said, yep, that's sufficient justification. That's a good, public safety law. This was under the old standard. So it was arguments like that were being upheld under this old standard. It was just anything the state said was justifiable. So now Bruin comes along and says, this entire test that they're employing, where you're balancing interests, and addressing court cases by applying levels of scrutiny, whether it be rational basis, intermediate, or strict scrutiny, that entire scheme is outright rejected. You cannot use this test. And instead, you have to make the test is based off text and history. And it's very simple. It says this: if the plain text of the Second Amendment covers the conduct in question, then it's presumptively protected by the Second Amendment. Then the burden shifts to the government, that they have to then go and identify historical analogous regulations from the founding era that would justify the current ban. So completely different situation than what it was. It used to be the burden was on us. We had to try to decipher all this mumbo jumbo junk science expert testimony that the states would use to justify these bans. And, courts would always rule in their favor because basically any justification was enough. That's now gone. Now you look at the text of the Second Amendment. It's very simple. Does that cover the conduct in question? Yes. Okay. Now the burden's on the government. We don't do anything. And the government has to prove that their law is justified by going back and finding relevant and analogous laws. And what I mean by that is laws that are, relevantly similar that would then say, like, okay, for example, if they prohibited the ownership and possession of firearms, of certain guns during the founding era, muskets or even cannons or Gatling guns, well, then that would show that, at least in the founding, there was some laws where the government was permitted to regulate the ownership and possession of firearms. Well, the thing is, there is no law. There's no law of any kind that prohibited the possession of firearms, any firearm, during the founding era. And I don't think, I believe in the decision, the court states that, according to one expert, the first outright ban on the possession of a firearm was in 1911. So that's a far cry from founding era, and it does not show a historical tradition of firearms regulation. And because of that, the law is unconstitutional. So this new test, where it just throws away all the garbage science, garbage opinions that used to be employed, is massive in the fight for Second Amendment rights. It truly has changed the game. I believe it's going to result in an era where bans on possession of firearms are just not going to be able to be done, and I think that's a wonderful thing.
And how did this? I read the decision, and just give us a synopsis of how Benitez arrived at his decision in this Miller case using Bruin.
Yeah, the decision's awesome. It's amazingly well written. Almost every instance, every statement is supported by factual evidence in the record, and there's no big leaps in logic or conclusions or anything like that. But it's very simple, just like kind of what I laid out. The decision starts off with, let's go with the plain text of the Second Amendment, the right to keep and bear arms. What is an arm? It's any weapon for offense or defense. And so it's very clear. These guns, they're arms, they're firearms. They easily fall within the plain text of the Second Amendment. So therefore, they're going to be protected by the Second Amendment. So now we shift to, the burden goes to the state. And they now have the burden to justify this ban. So now we got to look at the historical context to justify the law. But the thing is, with DC v. Heller, it already did the historical analysis when it came to firearms bans. Because when you go back to the Heller case, you see that Washington D.C. was trying to ban the possession of handguns. DC v. Heller, the Supreme Court back then, they went back and they already did the historical approach and said, well, based off of our historical review, the only firearms or the only arms that can be banned are those that are both dangerous and unusual. And if it's not dangerous and unusual, it can't be banned. And at that time, they were talking about handguns. And handguns, everyone has said they're the quintessential self-defense weapon. The public has overwhelmingly chosen handguns for any lawful purpose, whether it be self-defense, recreation, shooting, hunting, all that. So because of that, they're in common use, can't ban them. We had a per curiam opinion written in the Caetano case that later came out, and that reiterated this, dangerous and unusual test, and said that it's both. It has to be both dangerous and unusual in order to be prohibited, because if it was dangerous or unusual, or if you could just ban any arm that was dangerous, well, then the state could jump in and just ban everything, whether it's a Swiss Army knife or F-16. Everything's dangerous. If an arm is dangerous, they'd ban it. Well, that can't be the case. And so the Caetano court literally said this is a conjunctive test. It's both dangerous and unusual. And in addressing that test, they said, well, an arm that is in common use cannot be, dangerous and unusual because it's in common use. So that's the test. And, so that historical analysis already done. The court applied that test, using Bruin, citing to those cases, and said that there's quite literally no justification for the assault weapons ban. And although I think he didn't need to, the decision also goes into a lot of the various arguments that the state made that still would still fall under the interest balancing test that was outright rejected by Bruin. But he still kind of addresses those issues as a just in case you were wondering. At least that's how I read it. And really picks apart everything that, the main arguments that the state made, and shows that there really is no justification.
Yeah, one of the things that Benitez really paints a picture of when he breaks down the numbers in the decision, he talks about how many AR-15s crimes are committed with AR-15s, and it's something like point 0.000. I don't know how many zeros, but like a bunch of zeros, 9,437.
I think there's 5 zeros. I think it's 0.00087%. And that's if you assume that every single homicide that's committed with a rifle is an assault weapon. So I think the other way he put it was 99.999999832% of AR-15s are used for lawful purposes in this country. And I think that was in direct response to an argument that the state continued to make throughout litigation, that assault weapons are disproportionately used in crimes and all this stuff. And it's like, well, no, they're not. Quite literally, take the worst crime there is, homicide. If you take every single long gun that's ever been used in a crime, at least since in 2021, that's 274, I think, or 474. I forget the number, but that's in the entire country with 330 million people. You had under 500 homicides that were committed with any type of rifle. So to say that assault weapons are this major, catastrophic weapon of mass destruction thing, it's just factually incorrect, and there's no basis to make any type of claim. And it really just shows, these arguments are fear mongering. They're for the headlines, they're for news, they're for people to read at a glance and just assume like, oh yeah, well, guess we have a huge problem with assault weapons and people are dying. But the fact is that it just is not supported by any reality or any evidence.
One of my favorite lines, which comes from the conclusion, is that California's answer to the criminal misuse of a few, its many good residents. That knee-jerk reaction is constitutionally untenable, just as it was 250 years ago. The Second Amendment stands as a shield from government imposition of that policy. And I think that's so true that it just, like you're saying, they take fear-mongering where they take one tiny, tiny little case where one bad guy does something. So the knee-jerk reaction of a lot of those on the left is, well, let's just take all the guns away, because obviously no one can be trusted with guns, even though out of how many millions of people own guns, and nothing happens when you have lawful good citizens who own firearms.
Yeah, no, I completely agree. And, unfortunately, in the work that I've done, I've come to the conclusion that, you know, and I'm sure there's some people that will agree with me on this. These laws are not meant for our safety. They're not meant to make our world a better place. They're not written that way. They're not implemented that way. They don't do anything to actually help good law-abiding people. You know, and it's funny, in the decision, it actually references this fact. If I remember correctly, let's see, who was it? I think it was a reference to one of the experts in the case. Let's see. I think I have it here, so I can. It's just amazing.
Sounds like, like sound effects. Your keyboard. Like,
oh, sorry.
Like, no, it's fine. It just sounds like fake sound effects we like added in. Like,
yeah, it's a loud keyboard. I'll say that. Yeah, so it was. Let's see. Yeah, so John Donahue, I think, made the claim that these laws, they're meant to be implemented at an incremental basis. And I think that kind of tips the hand of the state. Is this isn't about like, hey, we'll make this law and this is what we believe will help people, save people. It's no. We want this. This is our goal. No guns, no private ownership of guns. We know we can't do that. You know, that'll send up some red flags, and even a lot of people that are more liberal or leftist or anti-gun will even say, well, you can't just outright ban all ownership of guns. You know, we do live in the United States and we do have a Second Amendment. So instead of doing that, they implement a law, and then they change that law and they implement it, make it a little more restrictive, and they go forward and, you know, incrementally make it bigger and broader. And we've literally seen that with the implementation of the Assault Weapon Control Act in California. In 1989, you had a limited list of firearms that were considered assault weapons. 2000, now we changed that. It's not just those weapons that are assault weapons. It's any weapon that has these features. And then after a few years, it's not any weapon that has these features. It's also weapons that have these features as well. And then we get to 2018. I think in 2020 even, they changed the law again while we're in litigation, defining an assault firearm because there's a development of a couple guns that didn't have rifling, but they were shoulder-fired guns, and so they didn't qualify as a rifle, they didn't qualify as a shotgun, they didn't qualify as a pistol under California law, so they were just a firearm. And so they changed the law again and be like, okay, those are assault weapons too. And so you can see how every iteration of this ban, they expand the definition of what constitutes an assault weapon. And every single time, they just try to lump in more and more into that definition. So it's telling in and of itself. It just shows you that, okay, they're not going to stop this. You think that, you know, they're going to stop defining what an assault weapon is in 2021? No. That in a couple more years, they'll redefine it and do it again. You know, we've seen that with, you know, we have the challenge to the roster requirements, and actually a successful challenge to the roster requirements in the micro stamping. Well, you already have, even though the micro stamping was held to be unconstitutional and they weren't going to enforce that, you already have a new bill. I'll admit, I don't know if he was even passed or still being proposed, that addresses micro stamping in the future and implementing that later on. It's like,
I think they passed it.
Did they pass it? Yeah. So,
hold on.
See, I'll admit, even someone working in this field, they pass these laws so often, it's hard for me to even keep track sometimes. It's crazy.
I have a list of like recent ones that Newsom signed, so I'll look and I'll let you guys know when I have the answer. Yeah,
and if, you know, speaking of our you know, our governor, you know, the fact that he's repeatedly said that he will sign any gun control measure that comes across his desk. I mean, sure. If you think about the implications of a statement like that, that's an absurd thing to say. You're saying you're going to sign things into legislation, into law, that you don't even know what it says. And to make a commitment like that just shows that he has no respect for your rights, my rights, the Constitution, or even due process in how this country is supposed to work. It's disheartening and it's frustrating to put that in good, appropriate language.
Yeah, and they're always, like you said, they're always encroaching. Like the recent, I don't know when they passed it, but it was if you add a handgun to the roster, you have to take like 2 off. So it was like slowly but surely, like there won't be any handguns left because they'll add 1, take 2 off, add it. So it's these little things that if you're not paying attention, slowly but surely, we'll all just be running around with like, small 22 like pea shooters, and that's the only thing that we can use to defend ourselves. Nothing wrong with people who prefer 20. That's where it's going. One of our good friends, Osvaldo from Triggerology in the chat says, John, I just found out my city in Pomona is using may issue language in their CCW application. Subjective good moral character and discretionary psych evaluate. Now, is that constitutional under Bruin or not?
I would say no, not at all. And in fact, I just saw something, I believe it was Gun Owners of America, stating something along the lines of the good moral character requirement in New York's concealed carry requirements was just struck down. I don't know. It was literally a headline. I glanced at it right before I jumped on here. But there's no way that those subjective tests can withstand any type of scrutiny under the Bruin test. And Bruin actually explicitly states in the decision that, the fact that, the CCW tests, they need to be applied in an objective standard, and you cannot use subjective requirements that can vary and change. And this good moral character is a horribly subjective requirement. Like, well, what is good moral character? Does it mean you've never committed a crime? Does it mean you have a bunch of reference letters? Does you got to get the pastor of your church to say, like, yeah, this guy goes to church on Sunday, every Sunday, never misses a beat. I really, tell me what good moral character is in the eyes of the state. That's not entirely subjective. And I haven't seen any language in any type of CCW requirement with this good moral character requirement that's not subjective. I believe a lot of counties and sheriffs, their unwritten opinion is good moral character is you don't have any convictions of any serious crimes. But again, even that is okay. Well, what kind of crime would make you ineligible for a CCW? Is it only nonviolent crimes? Is it some misdemeanors, all felonies? What's that? So I don't believe that this good moral character approach is constitutional in any way. I think that the psych evaluation, again, is even more subjective. And anyone who's, sits there and goes, well, if you have a psychiatrist, they have their professional opinion and they give it, that seems like a pretty objective standard. You have a medical professional making a determination. The fact is, anyone who's dealt with expert testimony knows that I can find an expert for any opinion A. I can then go find an expert for the exact opposite opinion B. There is no shortage of experts that will have contrasting opinions, and that's why we call it the battle of the experts. When you do have that in litigation, there's always an expert that'll say something different than another one. So it's not objective in any way to require psych evals, and I don't believe that they would withstand any type of real Bruin analysis at all. So hit me up, send me an email, let me know what the language is.
I mean, we did just live
the
through
answer.
2 years. Oh, go ahead, Camille.
Sorry, to go back to is SB 452, and Newsom did sign it, that requires the microstamping, including on ghost gun parts.
Yeah, and it's like, they've never even shown that microstamping can be implemented on a fire. There's not even a single prototype in this country that it even works, let alone the fact that you can file off any microstamping with a 99-cent file in about 3 seconds. It's not like this is ever going to help. But yeah, but going back to the CCW stuff, yeah, I think that county sheriffs really need to go back and review what standards they have. Although a lot of them went back and got rid of the good cause requirement, they need to go back again and really look at what Bruin says and look at what their requirements are, because I don't see any justification for those types of requirements of moral character, psych evals, or letters of recommendation. It's all entirely subjective, and it has no support.
Yeah, I was going to say before, we did live through about 2 years where you could get any experts in quote to get up on TV or parrot whatever the state wants them to say. So the idea that medical experts can be completely objective and not subjective is, I think, a falsity at this point. I agree with you.
100%.
I mean,
what
if it comes to a point where
if you didn't learn that from COVID, yeah, I don't know if you're ever going to learn it, but there's no question that this is not a matter that can be cited by some third-party expert or anything like that. So you should let your sheriff know, or whoever's in charge of the CCW process, be like, you need to get rid of this, or else they might get a lawsuit down the road.
2 comments. First, I just looked this month, I guess, in the last month or so, Newsom actually signed over 20 laws that are regulating firearms.
Yeah,
I think there's 23.
Yeah,
new ones.
So Chuck Michelle with the Michelle and Associates, they have their California gun laws book, and I remember just when it first came out, he'd do a new edition every year, every other year. Now I think they're on their 12th edition because they're changing the laws so much. He's got to rewrite the book every 3 to 6 months. It's absurd. But I laugh at it in the sense of it's just crazy that they got to write additions to this new book so often. It's absurd. And like I said, the laws that they're signing, they're mad that Bruin decided what it did, and they're mad that they can't use this old test and old standard anymore. So because of that, they're just passing anything they can to literally just stick it to gun owners and their citizens. And it's a horrendous thing, but it's true.
Now, to kind of give people some hope, because I get this question a lot about, well, they keep passing these laws and then we take them to court and then they appeal and then it goes up to the Ninth Circus. And then we go round and round and round, and it never. My whole thing is keep passing these laws because you're just going to build more case precedents and further strengthen Second Amendment rights. Is that a correct way to think about all these laws that they're trying to pass? Because it's just going to create.
I mean, I think that's.
Right.
Yeah, I think that's a good way of looking at it for sure, because like I was saying, the laws that they're passing, they're just mad. And so they're just passing anything they can to the point where it's just, an absurdity. I think it's SB 2 that's trying to basically make the entire state of California and every public place in the state a, quote, sensitive place where you can't carry it even if you have a permit to carry. I mean, it's like, that's absurd. We all know that's absurd. And we all know that that's not going to stand under a Bruin analysis. In fact, like they literally said in Bruin, you can't make the entire island of Manhattan a sensitive place. It just doesn't work. So, I think that by doing that, they're going to create their own bad precedent. That's true. I also think, if you're mad about having to go to court, fight for your rights, wait the 3 to 10 years to get through the court process and then have the decision in your favor. If that angers you and you're not doing everything you can to get local representatives and state representatives and federal representatives that are pro Second Amendment, like in office, then you should just keep your mouth shut and don't complain, because there's a reason why we are dealing with this in the long run. It's because for years we just let anti-Second Amendment representatives in office that had no respect for the Constitution, no respect for your fundamental rights, and we allowed them in office by being complacent, and that's just the truth of the matter. And because of that, we now have individuals and representatives ingrained that are just dishing out this type of legislation. So if you want to play the long game and truly win, then you got to be active. At the very least, you got to be voting and know who you're voting for, to get people that actually support your rights, that would defend the Second Amendment and your other, the other Bill of Rights and your other fundamental rights in office. And if you have those people in office, you're not going to deal with a bunch of laws being passed that violate your rights. So that's the, back it up long game of it all. If you're not at least being aware of who's running, who's in office, and who you're voting for, it's your own fault. Now, on the other side of that, there's always going to be some laws that are going to be passed, that get through the cracks, even if you have a lot of, good representatives. And we got to go through the court process. The fact is, we now have a standard that truly applies the Constitution, truly applies the Supreme Court precedent. And so while it is going to be a fight that's going to take a while, because you do have to get through the court process, and the good thing about that is that we all have due process rights, and you are entitled to appeals. And even though we may not like it, the state's going to appeal these decisions. We're going to have to keep fighting them, but we still have the Constitution, Supreme Court precedent, and our evidence on our side. We now have a standard that is a true application of the Constitution. So that's benefiting us. So I think we're going to end up on the winning side of this. You add in your point of, they're going to build bad precedent for themselves, where we're going to continue to get cases that apply the Bruin decision the right way and determine that these crazy laws are unconstitutional. So it's going to be a battle, and the battle's not going to be over tomorrow, but there's no question that the game has completely changed. You talked to me back in 2019, 2020, we would have had a very different conversation of, the outlook. I've always believed in what we argue in these cases and in this litigation. I believe that they're sound arguments and they're supported by the evidence. But I would have told you, like, we're not climbing a hill. We're not, going up a hill for this. This is we're free climbing Half Dome, El Capitan. This is how difficult this fight's going to be. The fight's still difficult, but it dramatically has shifted in our favor.
Yeah, especially as someone who is a CCW holder, SB2 definitely worries me, but I have faith that eventually it'll be overturned.
Should worry all of us.
But it will just take time.
So I know, yes, it's not going to be over tomorrow. It doesn't change things right away. But this is a monumental win to have a case like this come out of the California and the district courts in California. And I think it's the start of something good.
So we got a couple minutes left. I guess the last thing in terms of, it's hard to really kind of sum up. We've things. Would you give the people who are, would you say there is reason to be optimistic? Is there a brighter future for Second Amendment rights here in California on the horizon, or is it going to be dark for a little bit longer?
Oh, I definitely say there's a brighter future. There's no doubt about that. Like I was saying, the landscape has shifted. It's, the winds are in our favor. But that's not to say there's not going to be a dogfight for a little while, especially while we're getting these bills that are being passed just to kind of, because they're mad about Bruin. So, there's going to be litigation fights, especially in states like California, who tend to be the leaders in passing these, unconstitutional laws, we're going to have to settle that out, and that's going to take a while, anywhere from 5 to 10 years if you're talking about all the different cases challenging all different laws going up and down the court system. But it's undeniable that even with that fight ahead of us, we are in much, much better territory with the limitation that these courts have on them from the Supreme Court, that they can't just apply whatever test they want. They can't just, make up any justification that they want to uphold these bans. They got to actually go back. It's a factual matter. They got to go back and find laws that will justify the current law. And the laws are either there or they're not. If they're not there, there's no justification. So it's going to be a lot harder for states to kind of weasel around and get around the Bruin decision. So I think it'll be very beneficial going forward.
Well, John, thank you for coming on tonight and kind of dissecting all of this for us. Why don't you tell everybody where they can find you, follow you, interact with you, contact you if they have any Second Amendment questions?
Yeah, so again, I'm with the Dillon Law Group in Carlsbad, California. My email address is jdillon, DILLON, @dillonlawgp.com. I also have CA Firearms Lawyer on Instagram, Twitter, or X, whatever it's called now. So you can always contact me in any way like that. Yeah, always available to talk guns, no problem at all.
Well, I'd like to have you on again when I'm not dying of sickness. So let's have you on again real soon. We could dive into some more legal issues and really get in the weeds about this constitutional stuff, which I love to know.
Yeah, that sounds great.
Awesome. Well,
yeah,
definitely. As I like to end every show, thank you for watching. Camille had to dip out early, but just to end as we end every show, if you like it, make sure you like, share, subscribe, review, all of that stuff. And the best way to support this show that's absolutely free is you can share it with somebody. And in this case, share it with someone who's a Second Amendment supporter here in California, and share it so that they as a resource. So with that, have a good night, everybody.